A major U.S. immigration policy has been struck down by a federal court, giving potential relief to immigrant visa applicants from 75 countries. The Trump administration had suspended immigrant visa issuance for nationals of those countries, citing concerns that applicants could become dependent on government benefits. The policy was implemented by the State Department in January 2026. But on Friday, U.S. District Judge Jeanette Vargas ruled against the policy, finding that it violated federal immigration law and that Secretary of State Marco Rubio had exceeded his statutory authority. The court's decision is significant because the policy had effectively stopped immigrant visa processing for people based solely on their nationality. The ruling also means that visa refusals that were based only on the now invalidated policy have been set aside. The court did not order a separate review of those cases. The original policy was based on a broader public charge concern. The State Department had said it was reviewing applicants from the affected countries to determine whether they were likely to become dependent on government assistance. The legal challenge argued that immigration law requires individualized visa decisions rather than a blanket suspension based on nationality. It is important to understand what this ruling does and does not mean. This is a court ruling against the 75-country immigrant visa pause. It does not mean that every immigration restriction imposed by the Trump administration has been overturned. It also does not automatically mean that every visa applicant from those countries will immediately receive a visa. Applicants still have to meet the normal requirements for an immigrant visa, and other immigration restrictions or grounds of inadmissibility can still apply. For now, however, the ruling represents a significant legal setback for the administration's 75-country visa suspension. The next question will be whether the government challenges the ruling and what happens while any appeal moves through the courts. For affected families waiting for immigrant visas, the decision could reopen the possibility of individualized processing rather than a blanket nationality-based pause.